Good afternoon, everyone. Thank you for joining our monthly CLE. I apologize. We had a little technical difficulties, so I apologize for the delay in getting started. Um, my name is Kristen Solis. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program, or DVAP, as we affectionately call ourselves. For those of you that are not familiar with DVAP, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association, and our primary mission is to match low-income Dallas residents with private attorneys that will work their civil case pro bono. So today we are going to learn about driver's license restoration. That is one of the types of cases that we do take, and the reason we do focus on this type of law is not having a driver's license is a barrier to employment. So we do try to help folks get back on their feet, have all the tools they need to get employment to build better lives for themselves. We are blessed today to have Brittany Moore as our speaker. Brittany is a graduate of South Texas College of Law. She is a staff attorney at Legal Aid of Northwest Texas, and her primary focus has been on removing barriers for employment. So she has handled things like driver's license restoration, expunction, non-disclosure, things like that. She has been awarded the Impact Award from the State Bar of Texas Poverty Law Section in 2021 for her work in this area of law. So if you do have questions along the way, please put them in the Q&A at the bottom, and at the end of the presentation, Brittany will try to get to as many of those as she can. And without further ado, I will turn it over to Brittany.
Thanks, Kristen. And thanks, Maricela, as well, for getting us all set up. And again, I apologize for starting a little bit late, but let's just get going. Driver's license restoration. Generally speaking, just as Kristen said, the reason why this work is important is because not having a driver's license, this very basic thing, is a huge barrier to employment. A lot of jobs require driving, or they just want to know you can drive and come to work, right? And then a part of that is also just having that valid identification period. And so for a lot of my clients, especially my homeless and transient ones, they don't even have that. And you need identification to do anything. I mean, even access public benefits or enter homeless shelters, apply for housing programs, you have to have valid identification. And so that kind of encompasses all of the work that we do, along with the driver's license specific things that we do. It makes up about 50% of the civil legal needs of all of our clients. And so that's why we're really trying to reach out to more people to let them know we provide this service, and come get that help, because in the past, they focused on other things, not realizing you still need to start here, get that valid ID or driver's license, and then we can start addressing those other things more directly. But you can't do anything without a driver's license or ID. And so just kind of, I want to go through not just the law and legalese part of taking these cases, but also what happens when you take a case from us regarding driver's license and ID restoration. So the place that we start is we determine their citizenship and financial eligibility. As you all know, legal aid is restricted as to who we can represent. We can only represent those who qualify for us financially, meaning they fall below typically 125 to 200% of the federal poverty guidelines. So this is this very vulnerable population of people that often go unrepresented, do not have access to justice. And this is how we bridge that gap, is through legal aid and you, our volunteers. And so we do that screening once a case comes in, right? We have them fill out a driver's license questionnaire so we can kind of get an overview of what it is they came to us for and needed help with. And then we do a quick screening of what Texas DPS is telling us is an actual barrier to them getting their ID or driver's license. Once we find that, we get some paperwork filled out, and then at that point, those cases are referred to our volunteers and or an internal staff attorney who takes the case. So this is just kind of a screenshot of the two different searches that we complete to kind of, like I said, determine what the actual barriers are to obtaining their license or ID according to DPS. These are two public search engines. They're free. All you need is, as you can see here, the client's driver's license or ID number, their date of birth, and then for the eligibility page, the last four of their social. Anyone can do this. I send this link to clients. Volunteers should do this when they take one of these cases, even though I do it already, and I include that in the file that you'll receive. It's always good for you to follow up and make sure the information is still the same. And these are the two links and websites, which are in the instructions that I give in an instruction document that'll be attached to this PowerPoint and as part of the materials that you'll get at the end of this presentation. So here's an example of what the driver's license eligibility search will show you once you type in that information for a potential client. It'll tell you, for one, in that highlighted section, is their license eligible or not eligible, right there in big bold letters for you. And so that's really helpful, because then we automatically know, yes, it is eligible, or no, it isn't. And then as you scroll down on that same website, it'll then tell you why it is ineligible, if in fact it is ineligible. Here in this area to the right here, but in that first column, it'll say the title of the suspension or hold. And then it'll tell you when it began, when that suspension potentially can end, and then what they can do to remedy or lift that suspension from their driver's license. So as you can see, some of these end dates are 9/9/9. That just means this suspension will be here forever until you do one of these things that's here listed in the compliance instructions. I have some volunteers who ask, well, if this is spelled out like this for the public to be able to access, then why can't clients do this on their own? Well, as you peruse this column here to the right, you can see that some of these things involve court intervention, right? Requesting a court-appointed installment agreement, an SR-22 or notarized release, right? That's a release from the court. An SR-13, a judgment and creditor's consent to allow license registration. All those things are documents that have to be obtained from the court. And clients don't even know where to begin when it's something like that. For us, this is something that we easily get just by a phone call or a stop at the court, a couple emails, correspondence, we get it to DPS, the hold is lifted. But for a client, they're just like, what court do I go to? When I go to court, what is the SR-22? What is an SR-13C? They don't know what these things are. And that's part of the reason why this intervention and advocacy for us is so important. It's not only simplifying this process, but also letting people know that you can do it. And I can help you do that and do it quickly and get you a license, a valid driver's license, so you can get employment or benefits. Here in the bottom section, since other requirements, is typically the only other requirement that you'll ever see here. Let me see if I have it in the next slide. There it is this number 1 over here, is that you have outstanding citations under the failure to appear or failure to pay program. That's the Omni program that some of you might be familiar with or may have heard of before. These are basically outstanding citations or court cost holds that have then placed an Omni hold on their license. So that other website that I'm going to discuss here in a little bit, and that I showed you a screenshot of, is where we find those failure to appears. And those are a hold on someone's driver's license as well. So that's predominantly most of the, work that we do is these Omni holds. That's a majority of our cases. This second part, I left the screenshot this way so that way I can talk about it, but this number 2 section right here doesn't exist anymore. This is referring to another hold under the surcharge program that Texas no longer has. Up until 2019, we did have another barrier. So potentially what would happen to a person is they would get a ticket and they would owe the court something, right, for that ticket. And then if they don't take care of it, a warrant would come out, so on and so forth, right? So that's connected to the court. After that, they would then potentially, depending on what the violation was, if it was a moving violation, get a suspension from DPS, which is that box of columns with those suspensions that I just talked about. And then on top of that, they would owe money through this surcharge program that would then charge them almost on a monthly basis for certain citations. And that total would just continue to rack up over time until they paid it all off from beginning to end, the court process, lifted the suspension and paid the surcharges. Then someone could get their license renewed. It was exhausting for clients and even exhausting for me as an attorney when I was helping people through it. Now that program is gone. Now people just have to deal with the court citation directly and then the suspension if a suspension results. And I say that because some clients don't know that it's gone. And so they'll come to us and say, I can't get my license because surcharges, so on and so forth. And then I look it up and I tell them, hey, your license is actually eligible and those surcharges are gone. So you can go get your license. And sometimes my intakes and advice for some of my potential clients are just as simple as that. So that's the only reason I leave that number 2 there. You will never see it anymore, but I keep that there just so I can explain to you that people will ask about it because, like I said, it just happened in 2019. So about 4 or 5 years ago. So we still get clients that still don't know that that doesn't exist and that their licenses are actually eligible now. Here in this bottom box in this screenshot to the right, you'll see reinstatement fees. These are not tickets. These are not court fines. This is not something that actually renders their license invalid. These fees are just straight up administration fees that DPS charges for the different, there are 3 categories of suspensions with DPS, and this is a fee that they charge if you get an offense under each category. They do not charge each category more than once. As you can see in this screenshot, this person potentially had a hold under all 3 categories, but they could have had multiple under each one, and that fee is just charged one time, but that fee does have to be paid before DPS will issue them anything. So an ODL, a new driver's license, if they need to renew it, DPS is going to say your license, you can apply for one. You can take the test, but we're not actually going to send you anything until you pay your reinstatement fees. So that's just something we can't get around. There are potentially some agencies that will pay for this for some of our homeless clients, especially. But all in all, I just tell my clients, just go online, pay off as much as you can each time you get on. And then once it's done, then they'll actually send you your driver's license. And that's just the reinstatement fees. So I mentioned to you that there are 3 categories of suspensions. And this is broken down into 4 categories just for descriptive purposes, but it's really just these main 3 because the SR suspension kind of loops in together with the ALR suspension. But here are the those 3 categories that I described that will lead to that administrative fee. And you guys will get these slides if you want to read them in more detail. Within those categories are also these different types of ways that DPS will remove a license. It's essentially the same thing. It's still a suspension. It's still a hold. It's still just DPS telling you, by the way, you still can't get a license. So one of these 4 things will actually happen when someone keeps trying to get their license, even though they still have a pending suspension. DPS will say you have a prohibition, or your license was revoked, or denial, cancellation. You'll see those terms when you pull up that eligibility page. They all basically mean the same thing. This person still can't get their license for the reasons listed below. So it's just another way to kind of trigger and flag that, okay, what are their suspensions that we need to take care of so they can stop getting these denials. So here is a list of the various suspensions that a person can get on their license. And again, this is just general overview. If you want more detail, you can read this, but driving while license invalid, DWIs, drug offenses, not even linked to driving, just a drug offense period could lead to a DPS suspension. Evading arrest, boating while intoxicated, possession of more than 1 valid driver's license. You're only supposed to have 1 in your possession. These are all just examples of the many ways that DPS can suspend someone's license. Administrative suspensions and revocations. So these are ones that aren't directly linked to one act, but are rather an accumulation of different things that a potential client or person has done in order to get this administrative suspension. So driving while license suspended automatically triggers a suspension with DPS. Repeated traffic offenses, 4 or more, 7 or more, results in different lengths of a driver's license suspension. And again, here are some examples of that listed here. Being incompetent to drive, that's a common one. And then denial of issuance or renewal of driver's license. Again, here's another list of different offenses that can lead to that. I think the most common one that I see is the physical or mental incapacity. Because a lot of times that will happen at some point, but they then can still relieve themselves of that medical hold. You know, somebody loses, becomes colorblind or loses a leg. Things like that might trigger a medical suspension, but that doesn't mean they can't relieve that hold by then showing a court or a JP judge that, okay, I got the mechanisms in my car to be able to drive with 1 foot, or I have you know, a prescription that will help me see the color changes in traffic lights and signs, or some sort of drug dependency sometimes can lead to these medical holds. I have entered rehab. I can, you know, I'm sober most of the time now, or all the time now, rather. Things like that can relieve a client of that hold. There is a process to it. DPS has packets and steps that they need to follow that we also help people walk through in order to get that, you know, renewed bill of health, so that way they can drive again. And then another one that I'll see in this category is that delinquent child support. I think we hear it constantly in our different practices of law, that you can never get rid of child support. Child support arrearages never go away, and that is true also when it comes to your driver's license. So once somebody gets that suspension, it is basically one of 2 options. 1, paying whatever it is they owe, or 2, coming up with some sort of agreement or negotiation with the other parent and the Attorney General's office in order to relieve themselves of that hold, which is also a complicated process, but is possible. Court-ordered suspensions and revocations and cancellation, very similar to what we just talked about. Delinquent child support falls in that category. Mental incapacity, chemical dependence, failure to renew as a sex offender. I do see that every once in a while. And it's just, you know, sex offenders often move from state to state so that way they can gain employment, which is fine, but they still have to register once they move to a new state, especially if they're applying for a driver's license in that state. They not only need to register their move with the court of their offense, but they need to register their move with that state in which they're living in. And so a lot of people don't do that, and then they need to do it every year. That's a requirement in Texas. I don't know about other states, but I know in Texas, it's not just one time that a sex offender has to register. They have to report their current address every year. Otherwise, there will be a hold on their driver's license and it will render their license invalid. But the way to fix that is just to go register. So it's a pretty easy fix. And so when someone has some sort of restriction or suspension like this that isn't tied to a court citation, but is more a hard suspension, then what we can do in the meantime until whatever that suspension is relieved, we can get them an occupational driver's license. Occupational driver's licenses, despite the name, is not limited to just employment, right? It's more, it really should be called a necessity driver's license or needs driver's license, because if you can show any sort of essential need, you can get this driver's license. So my homeless clients, they're homeless. They need to be able to, you know, if they're looking to drive, they need to be able to they're probably doing that to gain employment, right? Which is a good enough reason for a judge to grant an occupational license. A single mother, she needs to drive her kids to appointments, to the grocery, she needs to drive to the grocery store. She also needs to drive to potentially get a job. That's a good reason to have to get an ODL. Someone who's taking care of elderly parents, they need to be able to drive their parents to their appointments, things like that. That is also an essential need. essential need that can be proven in order to gain an occupational license. This is a restricted license, so it only gives someone a certain time frame to drive. They have to log the hours for which they drive, and then they're only allowed to drive in certain counties, and that's all described in their corresponding court order for that occupational license. Typically, these licenses only last a year. So our method is to address whatever their underlying issue is, even if we have to get them an occupational in the meantime while we're working on that. Because that way, once that occupational expires, they can then still just get their regular license. Whereas if all we did was get the occupational, as soon as that expired, they were back where they started, right? So anyone that gets an occupational, we're still working on whatever their underlying issue is. So that way, once that expires, they can go and get their unrestricted regular Texas driver's license. So this slide kind of talks a little bit more about how to get it. Here's the description that I just described about an essential need driver's license. There is another type of ODL, and this is called an interlock ODL. These are specific to people with DUIs and DWIs who get the suspension from the court as part of their court order. People who fall in this category can get back on the road with an occupational license. This is a little bit more complicated area of representation. Essential need occupationals are straightforward. Like I said, you just prove the need. You have to get a driving record. The client has to maintain SR22 insurance. And as long as they do that, it'll be granted and DPS will send them that ODL. With an interlock ODL, a judge does need to grant it, and it's the judge that put the suspension on them. It's the judge who gave them that court order, and the same judge where they had their DUI case in, right? So that's typically in district court, and that's where you would have that hearing in front of that judge. And it is up to them to put them back on the road. And that's why I say it's a little bit more particular, because that judge has seen this client already on that case. So depending on the seriousness of that charge is whether or not the judge will grant it in that district court, as well as how often did they get DWIs, right? Someone that has 1 or 2, we will probably be successful in getting them that interlock ODL. But someone who's had 4 or 5, I do not see a judge putting them back on the road. In fact, that's never happened. And so I like to kind of try to make sure I understand the likelihood of that when someone comes to me with needing an interlock ODL, because I don't want to waste the client's time or money. Because as I said, they have to pay for SR22 insurance for the duration of while they have that occupational license. And that's money that a lot of our clients just do not have. So if I'm going to send them out to purchase this insurance, I want to make sure that they are going to have a high likelihood of getting this ODL granted. And so I definitely try to look up their criminal history, see if they've had DWIs in the past. What was this particular case about? Because when you go to that hearing, your adverse party is the ADA that was on that case, as well as the probation officer. In our case, most of our interlock ODLs are sent by the probation officer. So they're kind of rooting for this client to get their license so they can gain employment anyways. But every once in a while, it'll just be somebody who came on their own, and the probation officer is like, no, they fail their check-ins. They're not even doing good on their probation. That's a case where it's not likely that the judge will grant that ODL, and it's very likely that the prosecutor will oppose it. But in most cases, like I said, typically they're sent to us by their probation officers. They're doing well, and the prosecutor doesn't oppose, and they're still pretty straightforward hearings. It just requires a little bit of leg work as far as research goes before we actually petition. So that way I can prepare the client for what may or may not happen. So I mentioned SR22 insurance. SR22 insurance is a special type of insurance. I get clients all the time that's like, I keep getting these no insurance tickets, but I can't get insurance if I can't get a license, and I can't get a license because of my no insurance tickets. And I'm like, well, you can get insurance. They're like, how? I don't have a license. It's SR22 insurance. SR22 insurance is a special type of insurance specifically made for the people who can't have or don't have valid driver's license. That's its whole purpose, right? It's because people are going to drive regardless. The state of Texas knows that, DPS knows that. And so they just want to be able to say, hey, I know you don't have a car and I know you don't have a valid driver's license, but I know you're going to get behind the wheel, and we want to make sure you still have coverage in case an accident happens. If you do, that coverage is called SR22 insurance. Almost every insurance company has a policy like this. Whenever I have a client who has to obtain this type of insurance, I just let them know, shop around, just like you would with a normal policy, because there are some agencies that just have better prices than others. And if they tell them that they're working with legal aid, sometimes my clients might get a discount. But yeah, so that's what SR22 insurance is. And again, that has to be purchased and maintained while a person has an occupational license. And then this just talks about what happens once you get that license. So you petition the court, you go to the hearing, the judge grants it. If it's essential need, sometimes there is no hearing. The judge might just send back the order granting it. And then once you get that order, the client can drive walking out of that courtroom with that court order for 45 days. Excuse me, that court order is valid for 45 days. And that is because immediately at that point, they still have to send it to DPS. That 45 days allows for DPS to then receive that order and then return an actual physical card that is now their ODL. So that being said, they do have to immediately mail that to DPS. I have clients all the time who are like, I went to court, I got the ODL, and then I asked them, did you mail it to DPS after you got it? And they're like, no, I thought I was done. I'm like, no, there's a physical card that DPS will send you. And if you do not obtain that card before that 45 days ends, then you've pretty much wasted your time and you have to start all over again for another ODL. So very important that for my cases, when I take an ODL, I mail it out for the client. It's $10. So all they need to do is give you a $10 money order. I mail it out to DPS for them. And then that way DPS can process and send them that actual physical card through the mail. Another thing to keep in mind is after it's granted, in addition to the $10 for the physical card, they do also have to make sure their reinstatement fees are paid. Because again, it's not a ticket or something they owe a court, but it is an administrative fee to where DPS will just say, we got everything we need, but we're still not going to send you this card until you pay your reinstatement fees. So they do have to make sure that's paid before they will receive that card. They can send the payment with the ODL order and the $10, or they can pay it online beforehand, which is what I always recommend to my clients, especially while we're going through the process of petitioning, attending the hearing. I just let them know, hey, go ahead and take care of those reinstatement fees. So by the time we get our order, all we're doing is sending it to DPS, and then you can be on your way. And so that's how we handle just the suspensions part of people's barriers to their license. Overwhelmingly, the biggest underlying cause for someone's hold on their license are old citations and court costs and fees that our clients cannot afford. The reason civil legal aid is able to help in this area is because this is, although you can have counsel, you have a right to counsel, unlike higher level criminal cases, one is not automatically given to you. Right? Just like in immigration court, you have to go find your own. And in most cases, you have to pay for that. And again, for our clients, they can't even do that. And that's why we're able to fill in that gap. Also, the other reason we're able to fill in that gap is our representation does not center on entering a plea of not guilty or going to trial. We're not there to say necessarily that the client didn't run the red light or didn't run that stop sign. What we're there to say is, whether they did or didn't, what I do want to let you know is that my client can't pay this fine either way. So what can we do to take care of this fine? What can we do within the realms of what the law allows to take care of this ticket? Because it will never go away if you want them to pay this fine because they can't afford it. For my clients, this $300 ticket is their rent after their housing voucher. It is their groceries for the month for them and their kids. It's their electric bill, their gas bill. These are necessities that my clients are already struggling to meet, needs that they're already struggling to meet. And so this $300 fine for a normal person might be nothing, might be something they can just plan to pay off. But for my clients, it is giving up another essential need for them and their family. And that's why it's important for us to advocate for them and try to find alternate avenues that the law allows for us to do for them, so that way they can take care of these holds and have valid driver's license. So when we address these tickets, like I said, we go here to the right, you'll see the link to that failure to appear website, the Omni search that I was referring to, that will tell us what and where those holds for those outstanding fines and fees are. When we approach the court, here on the right side, these are the different options that the court will present. They'll give us sometimes dismissals. I didn't type that there because that's a given. If I can get a dismissal, of course, I'm going to shoot for a dismissal. But most often they'll say payment plan, they'll offer deferred adjudication. We definitely request time served if I know my client has served any time in the state of Texas. So I want to reiterate that time served is not just time served in that city for that specific ticket. Anytime a client has served in the state of Texas at any jail or prison in the state of Texas, as long as it was after the date they received that citation, they can use that to get time served. A lot of people think they have to be arrested for the ticket in order to get time served. That is not the case. The law allows them to use jail time or incarceration from any instance anywhere in the state of Texas, which is in any court's jurisdiction, and apply that to get time served. Time served credit right now is $200 a day. And then if all else fails, community service. Community service is ordered at a rate of $12.50 per hour minimum. And I stress minimum because they can mix, let's say a client owes $1,000 to a court. Dividing that by $12.50 still leaves them with a lot of hours. And so a part of our advocacy is to say, can we at least get a reduction so that way their total number of hours is more reasonable? They cannot order more than $12.50 per hour, but a judge can absolutely order less, which does happen often, because again, the goal is not to just bombard them with community service, because let's be honest, community service is a lot harder to do than if I had the cash to pay it, right? I could slide a card and go. But community service is a very active and time-consuming thing, which our clients are willing to do to take care of their tickets and get their license. We just want to make sure it's a reasonable number, and we can advocate for that, and we do. So again, they can't order more than $12.50 per hour, but they can absolutely order less. And then finally, a waiver due to a finding of indigency, which is where they'll take the conviction, but they waive the entire fine. That's something I always do for my disabled clients who would otherwise qualify for community service, but are unable to do it because of their disability. So really in those situations, I just send a proof of disability to the court, and so the judge can review it. And then in almost every case, they get that waiver. So the failure to appear website that I was just referring to is here. Here's that screenshot again to the right. And as you can see, it shows the name of the court, the address of the court, their phone number, their cause numbers, the date of the offense, the description of the offense, and then as well as what is due to that court. That being said, I do not stop at just this search, right? This search is a general overview of what DPS, what was reported to DPS and the Omni holds placed on the client's license. I still call those courts directly, well, really my paralegal does, to verify all of the cause numbers and all of the actual fine amounts that are with that court, because the court reports it once, and then later it doubles because of a warrant or failure to appear, things like that. They're not going to go back and report that again, more often than not. So we just call to make sure and verify that we have everything in our representation that we require in order to effectively advocate for that client, right? Because we don't want to just put this one cause number and then send our motion to the court when really they had 3 more open citations in this court. We want to include all 4 citations, so that way everything in that court will be clear by the time we're done with them, right? We want them to be able to get their license. So as much as we can, we don't want to leave any stone unturned, which is why we still with this court information, we still call them directly to verify, hey, my client had some holds here. This is what I can see. Are there any others? And they let us, the clerks will let us know, and we'll make sure to add that to our summary of the client's case needs. Here is an example of the template of the motion that I file with the court. And so I have a whole packet of pleadings that I give to all my volunteer attorneys and that I use on a day-to-day basis with my fines and fees cases. And so it includes a cover letter, the motion, a legal aid certificate letting the court know that the client qualifies for legal aid and may or may not be represented by an attorney, a pro bono attorney with legal aid, or or actually represented by me, an attorney within legal aid. This legal aid certificate is important. It's because it's prima facie evidence that this client is in fact indigent, right? We can only help people that fall below certain levels of the federal poverty guideline. So they should not question whether or not this client is indigent, and should not require an additional hearing. Of course, some courts do. We're fine with that. But we put that in there just to try to make this kind of streamlined process. So that way they don't really need to have a hearing for us. So again, it has a cover letter, this motion, our legal aid certificate, financial affidavit listing the client's income and expenses, and then a proposed order with all of the options where the judge can just check a box, send us the order, and then we're done with the case. Again, we have the need for this work is so great that part of my job was to create the streamlined process so that we can address this need for as many people as possible through both our staff and our volunteer attorneys, so that more people can get this help, get a license, and get a job. So this cover letter kind of describes for the court what we're trying to do. We know that judges and clerks don't really read our actual motions, so cover letters to me are important because if anything, they might read that. And it's just kind of telling, like I said, telling them what they're trying to do. I've updated this cover letter recently to include a statement about bonds if a bond is requested, and to address whether or not the case is pre-trial versus post-trial. Which there is a little bit of a difference if you've ever taken a traffic case. But again, this cover letter addresses that enough to where the cases should still flow in a very straightforward process. And then here's the motion. In that motion, I describe where the client falls on the federal poverty guidelines, their housing or living situation, employment situation, and if they may have served time. I include that as well, the location and the time period, so that way they can apply the credit as they see fit. That financial affidavit that I was referring to that lists the client's expenses and income is here. This is something that we as legal aid attorneys do every day. So it's pretty easy for us to walk through a client with this, excuse me. And in almost all of my volunteer cases, I've already done this for you. It's already in the file. So when you get the file, you'll get this already completed. I just ask that you review it with the client again to make sure it's still accurate as to the time you get the case. But when I get the case, this is part of my intake process because we have to verify income anyways. So why not just type it up all nice and neat? Because the cool thing about these cases is my client's qualification for our firm also happens to be able to be used as proof for our actual argument to the court for a finding of indigency. So when we go through that verification, we type it up here nice and neat and also have the client sign a sworn declaration. So that way you can also use that to send to the court as proof and evidence of their indigency. It includes, again, whatever percentage, their household size and percentage they fall under the federal poverty guidelines, any income they receive, including any public benefits, any assets they may own, and then their expenses. Even if it's an expense that's not being met, right? So what are you supposed to be paying on rent? So when my clients are like, well, I'm supposed to be paying $800 a month, but I just lost my job because I didn't have a license. So I'm being evicted. Right? Like I still put that there so the court's aware that this is what the client's the needs the client is supposed to be meeting, but because of their indigency can't. And that's why we're here. That's why we're arguing in front of you for other options so that way they can at least start to try to address that need. We also include here on number 8, a potential plea, right? We go over this with the client at intake and let them know that if they haven't already entered a plea, I would say definitely more than half of pleas already entered. But if they haven't, they're giving us permission to enter one with the court. Only a plea of no contest, but it's still a plea nonetheless. So we make sure our clients are aware of that at the start of the case. And the reason is because most judges don't grant this finding of indigency without it. And again, just because we're trying to kind of streamline this process, we go ahead and include that line here so the court's aware that if we need to, we are prepared to enter this plea if the judge needs it in order to make this finding of indigency so that we can proceed with either a waiver or community service. Here's a legal aid certificate I was referring to. Again, it just further proves up the client's indigency, so that way the judge can grant it and then should not have to have a hearing regarding that. And then finally, the proposed order. Again, this has been updated to include a few more things, but it basically lays out all the options that a judge can do. All of this is within their discretion. They can dismiss. A judge, prosecutors are not the only one with the power to dismiss. A judge can do so as well. They can waive it. They can grant community service, and then if they do, it has a little blank for them to tell us how many hours and when those hours are due. Which is important, of course. Once you get that community service order from a court, you want to let the client know as soon as possible so they can go ahead and start their hours to get that turned in before their due date. And so we talked about this, and the process is the different ways we resolve these omni holds. Is that time served request, community service, or the waiver for finding of indigency. A little bit more information about community service. There are many things that can qualify community service other than just working for a nonprofit. If someone is in a work or job skills program, that can qualify. If they are in a counseling program or GED program, that can qualify. Counseling programs and mentorship programs, that can qualify. Right now, I work with clients out of a rehab center. All the time they spend in counseling and rehab at that center, we can count towards their community service. Often, I've also been able to count time that a person has spent in class, and if they're furthering their education in college. I'll let a judge know and they'll say, okay, we'll count their time that they're actually in class towards their community service. Basically, anything that shows that the client is trying to do better to gain employment is something that a client can use for community service. And we absolutely have done that, have been successful, and judges love it. You know, knowing that they are not only giving this person an avenue to not have to pay this fine, which they can't pay, but judges love knowing that this person is actually trying to do something positive in their lives to affect themselves and their families. And so they love to grant these different things that are applicable for community service. You just have to let the judge know beforehand. So that way, once they get that order or certificate of completion, or the list of the hours they did in counseling or treatment, they're aware that, like, oh yes, I did approve this. This is great. Now we can zero out their fine and close their citations. So if you ever come across a client who mentions that to you, then you kind of want to make sure you bring that up to a judge or a court, plug it into your cover letter that they are in a treatment program or they are studying for their GED, and we would like the court to count that towards their community service. Issues with community service. It's not always perfect. Again, most of our clients more than happy to do it because that ticket is their problem. My clients, and it didn't just happen. For most of my clients, they've owed these fines and fees for over a decade. It's just, it became one ticket that then doubled. And then 2 years later, they got another one. 2 years after that, they got another one. And at no point were they ever able to pay it. It just racked up. And so by the time they come to us, we help them clear all of that so then they can get their license and kind of just start anew. Problems with community service, sometimes it's not completed on time. That's okay though. If a client is communicating with me and says, you know, my kid got COVID, then I got COVID, so I couldn't do my hours for a whole month. So I only did 10. That's okay. I don't mind going to a court to request an extension. Sometimes it's just a quick phone call, really, and they'll give them the extension. And then, like I said, it's just if the client's communicating. If they aren't, they fall off the face of the earth. Unfortunately, that does occasionally happen. You've still done your job. You've gotten them the order. The client can always still return to the court themselves and still request an extension and or then set up a payment plan, right, as their last default option. Here's some of the case law specifically that allows us to make these requests from the court. That request for finding of indigency that then allows us to get community service, a waiver, or dismissal. This is the section of the Criminal Code and Transportation Code that allows us to do so. So again, you can read this in more detail once you get the slides if you'd like. Article 45 is the biggest one. And then this again is more legislative updates. So we in Texas started working on this more proactively, I would say in 2017. And with each session have added more and more sections to the code in order to allow this process to be a little bit more accessible for the people who need it. And I just wanted to show you guys that so you understand that it's not really a fight with the courts. For the most part, the legislator and courts alike agree that something needs to be done with all these people with suspensions that can't afford to pay their fines and fees. It's a debtor's prison. And it's taking away a very basic need and right for our clients. And so everyone gets that something needs to be done, that reform needed to happen, and it is happening. And so these improvements to this code section and this area of law have been great. And it allows us to truly advocate fiercely for our clients in order to not only get a finding of indigency, but to get them community service, to get them something that they can actually do in order to get a valid license and a job. It's also why I just wanted to point out, we can still file this motion even if a plea is entered. In most traffic or any criminal offense, once a plea is entered, typically you can't enter into a case. Well, our legislative improvements in 2019 said, no, they still can. You can always go back to a court and tell them you can't afford to pay. Doesn't matter what stage the case is in. If there's still an open fine, then you can still go back to the court and say, hey, I can't afford to pay this. I need to do something else. And the law gives us the mechanisms to do that. Case outcomes. I like to tell all my volunteers this work, because we've streamlined it like this. I provide templates. I provide a step-by-step instruction. You will see that when you're emailed the materials after this presentation. It should require not more than 4 to 5 hours of work, probably including this training, actually. And again, I've done this so that way we can address this need for as many people as possible. And so in order to do that, I wanted to simplify this, make it quick, but also make you understand that it's a huge impact in these clients' lives. They are so grateful because, as I said, a lot of these clients have gone their entire lives without a valid license. They've gone 10 years or 15 years without a valid license. And it absolutely is life-changing to finally be able to have that little card that they were unable to obtain for all these years. So it definitely is a big impact for very little time investment, which I think is great. Some of the other benefits of volunteering with us, if you're not aware of, is you get malpractice coverage, you get access to all our trainings and CLEs, and I mentor you through specifically these driver's license cases. Every one of our cases, volunteer cases, have mentors that work with you. But a thing that's a little bit different with our driver's license cases is you get a subject matter mentor. This is all I do all day, every day. So I can respond in very specific ways to help you through that case if you need it. Because I have been to that court that I asked you to file in. I've talked to that judge. I have dealt with that court, and I know I can probably predict what's going to happen. And so if you have an issue or a question, I can pretty much answer 95% of them because I am a subject matter expert in this. And then this is what I do on a day-to-day basis. So it's not really taking away from my time to help you through these cases because I'm working on them anyway. And again, this is reiterating just what I talked about, all the things that you gain access to if you volunteer with us. The process for volunteering, DVAP gets you signed up. They send you the file, and as I said, that file will include their financial eligibility and citizenship eligibility, and then more often than not, that financial affidavit that you can include in the motion. We also provide you the template and instructions once you are sent a case, so that way you don't have to start from scratch. We don't expect you to build anything anew. I provide everything you need in order to make this, again, as streamlined as easy for you as possible. And questions, I see one in the chat. Oh no, that's Maricela. She gave you the course number for your CLE credit here in the chat box if you need it. And does anybody have any other questions? Finished right on time. It's 12:57. Thank you guys for your time. And I do believe that if you signed up to take a case, you'll be getting it here in the next week or two.
That is correct. Thank you, Brittany, for your presentation. For everyone who's tuning in, as Brittany mentioned, we will follow up via email regarding the case that you have signed up to take. That will be coming from Whitney Brahaney, DVAP Referral Paralegal. The CLE course number for today's presentation is 174-229-701. Again, that is 174-229-701. A copy of the slides will also be emailed out to you via Zoom. If you don't receive that email, I know we had trouble during our last CLE. You can reach back out to me on my email or contact Brittany with any subject matter specific questions. And she pulled up her email and her phone number on the screen. Again, thank you all for tuning in today, and we wish you a good rest of your day. Thanks, everyone.